Welcome back. We are now in the second half of the semester. And in the second half of the semester, we start to focus more on the business aspect of international business law. And when I mention business, what I'm specifically referring to is the buying and selling of goods, the international sale of goods. And in any international sale, there are going to be certain expectations, the expectations of the buyer, the expectations of the seller, and there are going to be a number of risks involved in that sale of goods. Now, in the modern world, sellers and buyers are often strangers. They don't have a prior course of dealing, and they may not trust one another. Now, as I mentioned, there are expectations and risks associated with any sales transaction. But those risks are even magnified in the context of international transactions. So it is incumbent on you as a future business manager to identify and manage these risks primarily through the contracting process. And so in the rest of this course, we're going to be talking about expectations, and we're going to be talking about the flip side of expectations, which are risks. And these are ultimately going to help determine how do we resolve contractual disputes. So in this lecture, we're going to look at the expectations and risks that are present in an international sales transaction. Starting with expectations. Now, in any sales transaction, and this could be you going to the student union to buy a bag of chips. It could be you buying an auto from a car dealership. It could be your business buying goods from another country. But in all of those cases, the buyer has certain expectations. And the number one expectation of the buyer wants to receive the goods. And not only do they want to get the goods, they want to get the goods that they bargained for, that they believed they were going to receive. And the buyer will not want to pay for the goods until they have a chance to inspect the goods, to ensure that they are satisfactory, to ensure that the goods are what the parties have bargained for. So the buyer doesn't want to pay for those goods until they finish inspection, because otherwise the buyer may pay for goods that are not the goods that were ordered and which they may not have a use for. And they may have to go now pursue the seller to get the actual goods they wanted, to take the goods back and then give me the actual goods. So in any sales transaction, again, very small, very large, the buyer's expectations are the same. They want to receive the goods that they bargained for, and they don't want to pay for the goods until they've had a chance to ensure that the goods are what they bargained for, that the goods are satisfactory. In the law, we call this conformity. The goods conform to the contract. Now, the seller also has expectations. And again, this is from the most minor of transactions to the largest of transactions. The seller wants to get paid. They want to receive their payment. And they want that payment as expeditiously as possible. Ideally, the seller wants the payment before it parts with the goods. Because if you ship goods that you haven't been paid for, those goods may be rejected, or they may be accepted and you don't have the ability to get paid for them. So ideally, the seller wants to get the money before it parts with the goods. Otherwise, they may have difficulty in recovering those goods. And again, this is true in any sales transaction. The seller wants to get paid, and the seller doesn't want to give up the goods until they have gotten paid to ensure that they are made whole. So those are the expectations of the buyer and the expectations of the seller. And they are true for small domestic transactions, for large international transactions. Let's talk a little bit about domestic versus international context. In a domestic sale, risks are much more manageable. Both parties have access to a great deal of public information. There are databases associated with a company, and so if I am contacted by a company in California that wants to buy the goods that I'm producing in Kansas, I can make inquiries. Are they in good standing? Do they owe back taxes? I can find those things out. I can also inquire about, are they honest? Are they dependable? What do the Google reviews say? And if we have a disagreement, we have multiple opportunities to resolve through either meeting face-to-face or a phone call or email or Twitter or some other form of communication. And if we're dealing in a domestic transaction, we're probably going to use the same language. We're not concerned about language risk. And the differences in state law are relatively minor. In the United States, we have a system, the Uniform Commercial Code, that applies to the law of virtually every state. Every state, with the exception of Louisiana, uses some version of the same law for sales. Difference in court systems, relatively minor. Court systems work the same wherever you go in the country. The court system of Alaska resembles the court system of Michigan, resembles the court system of Texas, resembles the court system of Oklahoma. Very few differences in how these disputes are going to be resolved. But of course, in an international sale, the risks are higher. Now, again, we start with the idea the expectations of the parties are the same, but things like time and distance change from just stumbling blocks to large obstacles. Communication is going to be much more difficult. We have time zones. There's a limited amount of time. If you are dealing with a company in Saudi Arabia, then you're dealing with an 8-hour time difference, meaning there's really only about a 4-hour time period in which you can communicate directly with the other company. There's also language issues. Now, you've probably all heard English is the international language business. Nevertheless, there's a lot of ambiguities that exist even in English. This just happened to me. As a matter of fact, I was making plans with another professor here at school, and we had agreed to do this on Wednesday. And so I said, I'll see you next Wednesday. And he said, well, do you mean this Wednesday or do you mean the following Wednesday? Because generally, we tend to look at next Wednesday not to be the next Wednesday, but the Wednesday after the next Wednesday. And it kind of struck me that I was about to go record a lecture on this exact topic of ambiguities in language. What does next Wednesday mean? What does next quarter mean? We need to know. We need to set that out in our contract. Now, there are other problems in an international sale, starting with trustworthiness. Is this company going to pay for the goods? Or is this company going to sell me goods that match our requirements? Are they trying to pull a scam? Are they creditworthy? Will this company pay me for the goods I am parting with? Can I rely on that? And of course, the risk of non-performance, which could be the failure to ship or the failure to pay, those are much greater in an international sale. So there's a number of risks that arise simply because of time and distance in any international transaction.